Under the new rule, these firearm owners will be required to obtain special registration.
They want to make it impossible to exercise Second Amendment rights, and what better way to do this than to make it difficult to purchase?
We've already lost more than 13,000 Americans to gun deaths so far this year.
By some counts, so far this year, there have already been 174 mass shootings
in the United States, and that is not what the Democrats are attempting to ban today, because that's already banned.
Hey there, folks. Let's dive into the big news. Judge Min, in what's being called a game-changing decision, recently took a sledgehammer to California's ban on so-called attack weapons. Buckle up, because we're about to unpack this ruling in an engaging and informal tone. So picture this. Judge Min steps into the legal ring, and with one mighty swing, he declares that California's ban on attack weapons is a violation of our beloved Second Amendment. If you're a gun rights advocate, this was like hitting the jackpot. You see, the Second Amendment is part of the U.S. Constitution that grants Americans the right to bear arms. And when a judge says the ban on attack weapons is a no-go, it's like saying, hey, you've got the green light to own these weapons. Now let's get into the nitty-gritty of what this means.
Weaponized against FFLs and the gun industry as a whole as a way of shutting down otherwise legally compliant FFLs.
Under the new rule, these firearm owners will be required to obtain special registration.
We are the only nation in the industrialized world that tolerates such gruesome statistics.
You've got folks who've been waiting for this moment for a long time, probably dancing in the streets. But there are others who aren't too thrilled about this ruling, especially those who've pushed for stricter gun control laws. This is where things get spicy. The judge's decision has ignited a blazing hot legal debate about gun control in California. On one side, you've got gun rights advocates who are celebrating this ruling as a victory for their constitutional freedoms. They argue that the ban on attack weapons was infringing on their right to bear arms and protect themselves and their property. These folks are probably popping champagne corks right now. But on the flip side, you've got those who see this ruling as a potential danger. They're concerned that easing restrictions on attack weapons might lead to an increase in gun violence and mass shootings. They've been advocating for stricter firearm regulations to keep communities safe. This is where the fireworks start. The ruling has set the stage for a massive showdown in California, with legal eagles from both sides gearing up for battle. You can bet that the appeals are flying in faster than a hot dog at a 4th of July barbecue. Constitutional challenge to California's gun laws. All right, let's get into the legal ring and talk about the heart of the matter, the constitutional challenge to California's gun laws, as seen in the Miller versus California case. It's like a courtroom drama, but way more intense. The folks behind this case, known as the plaintiffs, are basically saying, hey California, your ban on attack weapons is stepping on our constitutional toes. More specifically, they're talking about the Second Amendment, which is a big deal in the United States. The Second Amendment is part of the U.S. Constitution that says, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. In plain English, it means that Americans have the right to own and carry firearms. Now, the plaintiffs in the Miller versus California case are saying that California's ban on attack weapons is a violation of this constitutional right. They believe that folks should be able to own these weapons without the state getting in the way. That's where the legal showdown begins. Specifically, this case takes a magnifying glass to California's definition of what an attack weapon is. You see, the state has its own set of rules that define what falls under the category of an attack weapon. These rules aren't just about the type of gun. They also involve restrictions on who can own and possess them.
They want to make it impossible to exercise Second Amendment rights, and what better way to do this than to make it difficult to purchase
3-round burst or semi-automatic. Those firearms are not allowed for purchase in the United States today.
We submitted formal petitions for rulemaking through the appropriate channels, sir.
It's like a tight leash on who can have these firearms and how they're used. The plaintiffs are arguing that this definition and these restrictions go too far. They're saying it's like the state is overstepping its bounds by telling people what kind of weapons they can or can't have and how they can use them. It's a classic case of individual rights versus government regulation. So what we've got here is a legal tug-of-war. On one side, you've got the state of California saying these laws are necessary for public safety. On the other side, you've got the plaintiffs saying these laws infringe on their Second Amendment rights. It's a high-stakes game of who's right and who's wrong, and the outcome could have significant implications for gun owners, not just in California, but potentially across the country. As this case unfolds, keep an eye out for the arguments, the evidence, and the legal wrangling that'll determine whether California's definition of attack weapons and restrictions will stand, or whether they'll be found across the line when it comes to the Second Amendment. This is one of those courtroom battles that's got everyone talking, and it's far from over. Appeal process in the Ninth Circuit. Now let's talk about the appeal process in the Ninth Circuit. It's where the rubber meets the road after Judge Min dropped his legal shocker. This is the stage where things get really interesting. So, picture this. After Judge Min made his decision to strike down California's ban on so-called attack weapons, the state of California didn't just throw in the towel. Nope, they went for the big guns, or rather, the big lawyers, and initiated an appeal. An appeal, in simple terms, is like saying, hey, we don't agree with the lower court's decision, and we want a higher court to take a look at it. That's where the Ninth Circuit Court of Appeals comes into play. The Ninth Circuit is one of the 13 U.S. Courts of Appeals and covers a big chunk of the western U.S.
Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights.
We've already lost more than 13,000 Americans to gun deaths so far this year.
What we're talking about is a semi-automatic rifle.
It's a heavyweight when it comes to handling important legal cases, and this one is no exception. The appeal is like the opening round of a legal boxing match. It's the state of California one corner, and the gun rights advocates in the other, slugging it out with legal arguments, precedents, and of course the Constitution itself. This is where both sides get to present their case and try to convince the appeals court that they're in the right. But here's the kicker. This appeal isn't the final verdict. It's just the beginning of a series of legal moves in this game. It's like getting the referee's attention and saying, we need a second opinion. If the appeals court agrees with the state of California, the ban could be upheld, and Judge Min's decision could be overruled. If not, well, we could be looking at a whole new ballgame. Comparing Miller and Duncan cases. Let's take a look at a little courtroom showdown. The Miller case versus the Duncan case. They're like two separate episodes of a legal drama, each with its own unique plot, characters, and twists. First up, we've got the Duncan case. This one was all about California's ban on large-capacity magazines. You know, those magazines that hold a bunch of bullets? Well, the state had put the brakes on those, and Duncan challenged that decision. They said, hey, we have the right to own these large-capacity magazines under the Second Amendment. It was a bit like a battle over the size of a popcorn bucket at the movies.
President Biden and Steve Titelbach know that all-out gun confiscation is unfeasible, nearly impossible.
Where you guys worked with the ATF to change something that had been the law for 10 years to go after law-abiding Second Amendment.
By some counts, so far this year, there have already been 174 mass shootings.
Just how much can you have? Now let's switch gears to the Miller case. Here, the focus is on California's ban on so-called attack weapons. These are typically semi-auto firearms that have certain features and characteristics that put them in the state's ban list. The Miller plaintiffs are saying, hold on, we have Second Amendment rights too, and this ban is going too far. So what's the deal with the differences? Well, it's like comparing apples to oranges. Both fruit, but with distinct flavors. In the legal world, the Duncan and Miller cases have different arguments, procedural postures, and even potential implications. First, the legal arguments are not the same. Duncan is all about magazine capacity and whether limiting it infringes on Second Amendment rights. Miller, on the other hand, is about the ban on specific firearm features and characteristics. It's like arguing whether it's the cheese or the sauce that makes the pizza great. Different ingredients, different arguments.
In the United States, and that is not what the Democrats are attempting to ban today because that's already banned.
Did you or anyone in your organization communicate with the ATF?
The Second Amendment is what stands between Americans and anarcho-tyranny, and many know this.
Next, we've got the procedural posture. In Duncan's case, there was a temporary period known as Freedom Week, when certain magazine purchases were allowed before the state tried to slam on the brakes. Miller, however, had a temporary stay on enforcement from Judge Min that's set to expire. So, different timelines and situations entirely. And then there are the potential implications. A win for Duncan could mean that Californians can keep their large-capacity magazines, while a win for Miller could have broader implications for semi-auto firearms and their features. One is like saying, you can have that big soda, and the other is saying, you can choose your pizza toppings. So what's the bottom line? These cases are not one and the same, despite both challenging California's gun laws. They each have their unique legal battles, and their outcomes will affect different aspects of gun ownership. It's like following two separate TV series. You never know which one will have the bigger plot twist, but you're definitely in for some legal drama. 10-day stay in the Miller case. Let's dive into the legal realm and talk about what's happening with that 10-day stay in the Miller case. It's like a timeout in a high-stakes game, but this timeout could affect a lot more than just the players. So, picture this. Judge Min, after dropping the legal shocker and declaring California's ban on so-called attack weapons unconstitutional, hit the pause button. He issued what's called a stay. What's a stay, you ask? It's like a temporary freeze on the enforcement of the judge's decision. In simple terms, it means that the ban on these attack weapons won't be lifted just yet. Now, here's the catch. This stay is only for 10 days. It's like saying, okay, everyone take a deep breath and hold on for a moment. We need to figure out the next steps. The clock is ticking and the stay is set to expire on a specific date. But here's where things get interesting. The duration of this stay and whether it gets extended is a make-it-or-break-it aspect of this legal showdown. If the stay isn't extended, it's game on, and the ban on these attack weapons would be lifted. People who own or want to own these firearms would be allowed to do so. But if the stay does get extended, it's like saying, hold on, we need more time to think this over. The ban remains in place while the legal gears continue to grind.
Strategy we have observed and that we will discuss today involves targeting firearms.
Another way the ATF has been expanding its authority is by targeting legal federal firearms license holders, or FFLs.
Every day, more than 100 people in America die from gun violence, and many more.
This extension decision is no small matter and could have significant implications. It's like deciding whether to call an extra inning in a tied baseball game. And here's the thing. This decision doesn't just rest on the judge's shoulders. It could go to a different panel within the Ninth Circuit for consideration. The Ninth Circuit is like the referee in this legal match, and they get to make the call. So what does all this mean for the folks involved? Well, it's a waiting game. People who are passionate about their Second Amendment rights are watching the clock and the legal maneuvering. If the stay isn't extended, they could get a green light to own these firearms. But if it is extended, the ban remains and the legal battle continues. So, you see, that 10-day stay is like the ticking heart of this legal thriller. Its duration and whether it gets extended will determine when and how this groundbreaking decision takes effect. We're all in for some nail-biting suspense as we wait to see which way the scales tip in this legal drama. Procedural differences between Miller and Duncan. Alright folks, let's break down the procedural differences between the Miller and Duncan cases. It's like comparing two different seasons of your favorite TV show. Similar characters, but a whole new plot. So in the case of Duncan, the state of California originally didn't request a stay on the enforcement of the large-capacity magazine ban. It's like they said, we're so sure we'll win this one that we don't even need a timeout.
Here's a 12-round magazine. This magazine would be banned under this current bill. It doesn't fit.
Why is the ATF trying to say a pistol's no longer a pistol? If you use a pistol brace, it's a short barrel rifle.
This decision led to what's now famous as Freedom Week. During this period, Californians could go out and purchase these large-capacity magazines without facing legal repercussions. It's like a bonus round for gun enthusiasts. Now, let's flip the channel to the Miller case. Here, it's a different story. Judge Min himself issued a 10-day stay on the enforcement of his decision to strike down California's ban on attack weapons. This temporary stay meant that the ban wouldn't be lifted right away. It's like hitting the brakes on a race car that was about to zoom ahead.
Maybe 3%, maybe 5%, but we're looking at what could have prevented 90% of the mass shooting.
These procedural disparities are like comparing apples and oranges. In Duncan, the state of California chose not to ask for a stay initially, and this led to Freedom Week. But in Miller, Judge Min hit the pause button, and the case has a built-in delay, giving time for legal maneuvering and appeals to happen. So, why does this matter? Well, it's like saying the path each case takes is entirely different. The procedural differences mean that Miller's legal journey has its own unique twists and turns. It's not just about the ban itself, it's about how the legal battle unfolds. And believe me, this isn't your typical courtroom drama. The differences in timing and approach will play a significant role in how these cases progress and ultimately how they impact the rights of gun owners. It's like two different games being played in the same league, and we're all waiting to see which team comes out on top. Ninth Circuit's role in the legal battle. Alright, let's talk about the Ninth Circuit and its pivotal role in this legal showdown. The Ninth Circuit is like the big stage where all the action happens, and it's a big deal in the Miller case. First, let's set the scene. The Ninth Circuit Court of Appeals is known for its size and complexity.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
It's like a sprawling city with various neighborhoods, each with its own vibe. This circuit covers a massive part of the western United States and hears a lot of significant cases. So, it's like the grand arena where the legal gladiators go at it. Now here's the scoop. The Ninth Circuit has different panels, like separate teams of judges who handle various aspects of cases. Some of these panels deal with stay extensions, others with appeals, and still others with potential reviews of lower court decisions. So when it comes to the Miller case, these different panels will take center stage. They'll be the ones deciding whether the temporary stay should be extended, whether the state's appeal has merit, and whether there should be a review of the lower court's decision.
Completely ignoring the realities of the modern day horrors of gun violence we see play out each and every day. That you'll take down every single one of you in a matter of seconds. These just weapons of pure mass destruction.
For God's sake, America already has more guns than people. How many guns do we need until everybody is safe?
Why does it matter? Well, it's like having multiple referees in a game. Different panels may have different opinions and approaches, and their decisions will determine the course of the case. The outcome could swing one way or the other based on the panels that get assigned. The Ninth Circuit isn't just any old courtroom, it's like the Coliseum of the legal world, and what happens there has far-reaching implications. So, as the Miller case unfolds, all eyes will be on the Ninth Circuit, waiting to see which panels weigh in and how their decisions shape the legal battle. It's like a high-stakes chess game, and the Ninth Circuit holds a lot of the pieces. Key judges involved in the case. Let's meet the key judges involved in the Miller case. It's like introducing the main characters in a legal thriller. These judges come from diverse backgrounds and have different judicial philosophies, and their decisions are being watched like a hawk by legal observers and interested parties.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
That you said that all assault weapons should be banned. Is that a fair statement?
First up, we've got Judge Min, the one who made that groundbreaking decision to strike down California's ban on so-called attack weapons. He's like the lead character in our story, the one who sets the stage for all the drama. Judge Min's decision was the catalyst for this legal showdown, and it's his stay that got everyone talking. He's the one who initially said, "Hold on, let's take a break here." His background and legal philosophy are under the microscope. Then we have the judges who might weigh in on stay extensions, appeals, and potential reviews. These judges are like the supporting cast, playing crucial roles in the legal drama. Their names might not be as widely recognized, but they have the power to shape the narrative. We're talking about judges who come from various backgrounds and bring different perspectives to the table. Some might lean more conservative, while others are more liberal in their interpretations of the law. Their decisions could determine the course of the case, whether the ban gets lifted, and whether the state's appeal is successful. They're like the writers of the script, deciding which plot twists happen next.
Background checks on ammunition, waiting periods, and red flag laws, saving lives.
Americans have the fundamental right to keep and bear arms that shall not be infringed.
We know gun safety saves lives, period, full stop. It doesn't save every life. We're not solving for every incident. I get that. We're humbled by it.
So as the Miller case unfolds, all eyes are on these judges. Their backgrounds, philosophies, and decisions are being scrutinized like the plot of a best-selling novel. The legal world is on the edge of their seats, waiting to see how this ensemble cast of judges will shape the outcome of this gripping legal drama. It's like a courtroom version of Game of Thrones, and everyone's wondering who will emerge as the legal king or queen in the end. Potential outcomes for the stay extension. The temporary stay on the enforcement of California's attack weapons ban is like a timeout that needs to be extended or made permanent to have any effect on the lower court's decision.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
That men and women in this country have the right to defend their own lives.
If the stay isn't extended, it's game on, and the lower court's decision to strike down the ban would take effect. This means that people would be allowed to own the previously banned firearms. It's like saying, no more restrictions, have at it. But if the stay is extended, it's like saying, hold on a minute, we need more time to figure this out. The ban remains in place while the legal wheels keep turning. An extension would mean that the ban stays and the legal battle continues. It's like saying, we're not done here, the story's not over. Now, who gets to make this critical decision? It's the panels within the Ninth Circuit, like the referees in this legal game. The different panels might decide whether the stay should be extended or made permanent. This is where the drama unfolds. Their decision will have a significant impact on the case's progress. If the stay isn't extended, it's like one direction for the story. If it is, it's like choosing another path. And that choice could affect the ultimate outcome of the case.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
Including whether the ban on attack weapons in California remains in place or is lifted. It's a pivotal moment in the legal storyline, and we'll all be watching to see which way the pendulum swings. Supreme Court review and future cases. The prospect of a Supreme Court review is like the climax of a legal drama, and in the case of Miller versus California, it's a discussion that's making waves. While the legal world buzzes with debates and speculation, there's another case on the horizon that's raising eyebrows: Bianca versus Maryland. These cases are more than just legal showdowns. They're part of a broader narrative in the ongoing battle over gun rights in the United States. First, let's focus on the Miller case. It's the one that's been in the spotlight, challenging California's ban on so-called attack weapons. Judge Min's decision to strike down the ban is like a game-changing plot twist. Gun rights advocates are celebrating, but the state of California isn't throwing in the towel.
That's what gun control is all about. The ultimate goal is an unarmed and subjugated America.
Well, Mr. Wilcox, there's no law. Congress didn't pass it. That's a rule from ATF.
They've initiated an appeal, and the Ninth Circuit Court of Appeals is where this legal ping-pong match is being played out. Now, let's talk about the elephant in the room, the possibility of Supreme Court review. It's like saying, okay, let's take this to the highest court in the land. This isn't a decision to be taken lightly. The Supreme Court picks and chooses which cases to hear, and the timing of such reviews is crucial. In the context of gun rights litigation, it's like selecting which chapters of a larger story to tell. But hold on, there's another case in the wings: Bianca versus Maryland. This case involves the state of Maryland's ban on so-called attack weapons. Sound familiar? It's like the sequel to Miller, dealing with a similar theme but in a different location. The key difference here is that the Supreme Court had originally granted, vacated, and remanded the case back to the Fourth Circuit after its landmark decision in the New York State Rifle and Pistol Association versus Bruin case.
Under the new rule, these firearm owners will be required to obtain special registration, surrender or destroy their brace.
Percentage of the shootings were done by semi-automatic weapons or rifles. The number one weapon that they use, basic pistol.
Now, why is Bianca important in the broader context of gun rights litigation? It's like the companion piece in an epic saga. While Miller is making headlines now, Bianca is further along in the legal process. It's like saying, this story has progressed further and it's ready for a broader audience. The timing and selection of cases for Supreme Court review are like selecting the climax of a novel. It's about finding the right moment to deliver the most impactful message. While Miller might be a contender for Supreme Court review, Bianca's progress and the fact that it was already GVR'd make it an attractive candidate as well. The Supreme Court could choose to hear one, both, or neither of these cases. In the broader narrative of gun rights litigation, the selection of cases for Supreme Court review sets the tone for the entire story. It's about addressing the constitutional questions surrounding the Second Amendment and individual rights, which have been a hot topic for years. So, as we follow the legal developments in Miller and Bianca, we're not just watching individual cases, we're witnessing the ebb and flow of a larger battle over gun rights in the U.S. These cases are like chapters in an ongoing story, and the Supreme Court's decisions, or its choice not to review, will determine the plot's twists and turns.
Running for President of the United States wanted to strip away our enumerated constitutional rights.
Banning a class of weapons that you don't like the look of, not because of functionality.
The narrative continues, and we're all waiting to see what happens in the next thrilling chapter. That's all for this video, folks. See you next time.